Namaskar. Hijab controversy and the split verdict on the matter by Supreme Court of India has raised, in fact, more questions on the issue than it has answered the issue. But to understand those deeper questions which might have larger impact on society, we first must understand what arguments and what counter arguments were given by both the parties in Karnataka High Court as well as in Supreme Court of India. These girls who are demanding to lift the ban on hijab in schools of Karnataka, their first argument was in Karnataka High Court that banning the hijab is violating their fundamental right under Article 25 of Constitution, the right that gives them freedom to follow any religion or any religious practice. They said that since hijab is an essential religious practice of their religion, so it cannot be banned under this article. And to establish their point, they try to take help or they try to refer to an earlier Supreme Court verdict, which was in the case of Azmal Khan versus Election Commission of India. Their second argument was that this ban on hijab is also violating their fundamental right of free expression, that is under Article 19. They said that in an earlier case in Supreme Court of India, that was NLSA versus Union of India, it was established that a person can express his or her ideas not only through spoken or written words, sketches and drawings, but also through what he or she wears. And they said that since hijab is a mode of expressing their separate identity, so banning the hijab means banning the right to freedom of expression. They further said, very interestingly, that a ban on hijab is also violating their fundamental right to life under Article 21. Because they said that, again in an earlier case of Puttu Swami versus Union of India, it was established that a person's privacy is extremely important for a meaningful life. So they said that if the right to privacy is being violated, means right to life is being violated, and hijab is a mode of protecting their privacy. So banning the hijab means violating the right to privacy, ultimately violating the right of life under Article 21. They further said that this ban on hijab is also violating their fundamental right of equality before law under Article 14, because some other students with some who are having some symbols on their bodies are being allowed to enter the classroom while they are not being allowed, so it is not equality before law. Again, they said that this ban on hijab is also violating their fundamental right of non-discrimination on the basis of gender, which is under Article 15 of the Constitution. They said that because they are girls, they belong to a particular gender, so they are not being allowed to enter the classroom is violating their fundamental right of non-discrimination on the basis of gender. Apart from these arguments, they also said that the school body, that is College Development Commission or the College Development Committee CDC, is not authorized, is not a lawful body to issue such notifications banning the hijab. They also said that this school body CDC is also having certain MLAs, member of Legislative Assembly of Karnataka, as office bearers, as functionaries in this school body, and they belong to a particular religion, particular belief, particular ideology, so an unbiased approach towards us from them cannot be expected. They also said that the primary function of an MLA in assembly is to make law. It's not his or her function to sit an executive body and issue notifications as a government body. So they said that if this is allowed, then the separation of power doctrine of the democracy will be destroyed. What is separation of power doctrine? It is judiciary cannot function as a government or executive. Executive cannot function as judiciary. Legislative cannot function as judiciary, and vice versa. So they said that these MLAs are being allowed here in an executive body is destroying this this concept of separation of power. In the last, they also pleaded that they may please be granted a reasonable accommodation, in the sense that they be allowed to enter the college or the school with their hijab, and in which the color of hijab should match with the color of their uniform. So in this way, they said that uniformity also will not be destroyed. So this was all about their arguments. But then state government, the Karnataka state government, through its law officers, very forcefully countered all these arguments. The Karnataka government said that in no scripture of this religion, in no text, in no holy book of this religion, and in no other High Court or Supreme Court verdict, it is established or it is written that hijab is an essential religious part or practice of this religion. They also quoted several other Supreme Court verdicts. One of them was Ismail Farooqi versus Union of India. So they said that saying that this ban on hijab is violating this fundamental right is completely out of context. They further said that even if hijab is an essential religious practice or part of this religion, the same article, that is Article 25, also mentions that state can put some reasonable restriction on this right to religion if it is in the interest of maintaining public order, maintaining public health and public morality, or also maintaining other fundamental rights. So they said that banning the hijab in a school for a few hours is a reasonable restriction in order to maintain public order or uniformity in the school, and the school or college is nothing but a qualified public place. As far as Article 19, that is freedom of expression through hijab in this case, and Article 21, the fundamental right of right to privacy and right to life are concerned, the Karnataka government said in the court that both these articles have this caveat also, that in the larger interest of national integration and also in some other circumstances there can be some reasonable restriction on these fundamental rights, and banning the hijab is nothing but a reasonable restriction. The same thing they said about Article 14, equality before law, and also Article 15, that is non-discrimination on the basis of gender, that for these articles also reasonable restrictions can be put. So this was their argument. They also said that this school body which has issued the notification is quite authorized and quite a lawful and legal body, because it has been formed under Karnataka Education Act 1983. As far as the separation of power doctrine of the democracy is concerned, the Karnataka government said that in the Westminster form or style of governance in democracy, it is quite possible that a legislature can sit in an executive body and can work as a government. So this was all about the counter argument given by the Karnataka state government through their advocates, through their law officers. Now Karnataka High Court sat to give the verdict. So Karnataka High Court first said that these girls have completely failed to establish that hijab is an essential religious practice of their religion. So to say that this ban on hijab is violating their fundamental right of religion is completely out of context. The Karnataka High Court, in support of their statement, also gave several instances or several reference to the holy scriptures of this religion, to earlier High Court verdicts, and to some textbooks on this religion. One of the textbooks which they mentioned was Quran text, translation and commentary by Yusuf Ali. And they said that in this textbook it is mentioned that hijab is not at all a essential religious practice of this faith or of this religion. Why this book is important? Because Supreme Court, not High Court, but Supreme Court in certain earlier cases had taken reference or taken help of this famous textbook or this famous book on this particular religion. And one of those important cases was Sarah Bano case. As far as Article 19 and 21, that is freedom of expression through hijab and the right to privacy and right to life are concerned, the Karnataka High Court said that both these fundamental rights have a caveat, that a reasonable restriction can be put in the larger interest, and ban on hijab is reasonable restriction. As far as Article 14 and 15, that is equality before law and gender discrimination is concerned, Karnataka High Court said that it is too far-fetched to imagine that by wearing, this ban on hijab or by sitting in the classroom, that too in all girl classroom without hijab, is violating the fundamental rights of equality before law and gender discrimination. It is too far-fetched, and these fundamental rights should be seen in some context, and the context is to maintain uniformity in a school or in a college. So this is completely out of context. This argument does not hold water. Karnataka High Court said that this school body, that is CDC, is completely competent and authorized to issue such notifications of banning the hijab, as far as granting a reasonable accommodation that they be allowed to wear the hijab in the classroom of the color which matches with the color of the uniform. Karnataka High Court rejected this plea, and said that if this accommodation is allowed, then it will not remain a uniform. So this was all about what Karnataka High Court said in its verdict, and this verdict was unanimous verdict. Now, after that, these girls went to the Supreme Court. What happened there? What was the split verdict? What was the argument? We'll see in the second part of this discussion in the next video. Please do not forget to subscribe this channel and like this video if you have liked it. And till I come back with the second part of this discussion in the next video, I thank you very much, and please have a great time and good luck to you. Thank you very much.